Does horseplay that results in a job injury at work prevent recovery of workers' compensation benefits? That was the question in the case of the job site jokers. In this case, an employee was a contract laborer who worked on a concrete foundation crew. His work involved idle times. It was not unusual to wait for other work to be completed before his crew could continue. During breaks in work, employees were expected to clean the site and put away tools, but the workers would often play jokes and tricks on each other. One hot day, while waiting for a concrete truck to arrive, the crew took an early lunch break. Wanting to sit inside an air-conditioned truck, the employee tricked his coworker into getting out of the cab. He took the cool spot in the truck and after a few minutes returned to the job site. He then saw the tricked coworker. The coworker gave chase. The employee jumped across a trench and he broke his ankle. The employer's insurer denied his workers' comp claim upon the ground that horseplay was not condoned, and therefore the injury did not arise in the course of his employment. The Department of Labor denied the claim, and the employee appealed. How would you decide this case? Was the Department of Labor correct in determining that the employee's act of running on the job site and attempting to jump over a trench was a substantial deviation from employment, and therefore not in the course of his employment? We'll be back in a moment with the answer. Did horseplay amount to such a deviation in his employment that his broken ankle would be denied as a workers' compensation claim? No, said the South Dakota Supreme Court. This case was about horseplay on the job and when it is such a departure from work that it will defeat an injury claim. In horseplay cases, the court considers 4 factors: the extent and seriousness of the deviation, the completeness of the deviation, the extent to which the practice of horseplay has become an accepted part of the employment, and last, the extent to which the nature of the employment may be expected to include some such horseplay. One of the critical considerations in this case was that it was not uncommon to have a lull at work. The court noted, when there are no duties to perform, there is no work to abandon, and it is common knowledge that idleness breeds mischief, so that if idleness is a fixture of the employment, its handmaiden, mischief, is also. However misguided the employee's momentary and impulsive deviation during a lull at work, it was insubstantial. The Supreme Court reversed the department and awarded the employee workers' compensation benefits. Remember, it's a matter of law.